All right.
Hi, everyone. Carmen Disco here on Launch Network for the UIA Education Series. We've got another great one for you today. If you missed the PGA Merchandise Pitch Panel, please go on out to our YouTube page and check it out. It was awesome. We had some really, really cool products. And today, we're going to be talking to Elizabeth Dougherty from USPTO. She's going to have some really cool stuff to talk about. I am going to hand the reins over to Kathy Kirik. But first, Kathy, are we doing our award yet today?
Yes, we are. We are going to do the award. So yes, we had the Pinnacle Award. The United Inventors Association, typically when we go to the trade shows, we like to present some sort of little awards for everybody at the trade show. So because this was our first virtual one, so we're going to do what we call the Pinnacle Award, which is the award that kind of covers all the categories. Understanding that for an inventor, the challenges of bringing a product to life, of coming up with something marketable, of getting the finished product together, and doing a great pitch. We kind of just wanted to recognize you for that. So, drum roll, Carmine.
Drum roll. All right, hang on a second. Let me see what I can do here. I think I have the award.
Now, there's no cash that goes along with this award. Sorry, guys.
Let's see if I can find it. And the winner is the Rate Caddy.
Yay!
That was a great product. It's pretty crazy because we took a while, right, Kathy? We were debating for a while on all the products. They were all awesome.
Yeah.
Everyone did a great job pitching. They were all super close. And we just want to congratulate Michael White, great pitch, and the Rake Caddy. We think it was all good. Any questions you guys have, please get in touch with us. We'll let you know why we ended up going with the Rake Caddy if you want to know. And we'll let you know how we believe you did with your pitch on off mic, and we'll let you know. So, all right, Kathy, you want to do a quick intro, and we'll get this on show on the road.
Well, it is my pleasure to introduce my former colleague, Elizabeth Dougherty. In my previous life, I worked at the U.S. Patent and Trademark Office for 29 years. 20 of those years, I worked with Elizabeth Dougherty. She started off as a patent examiner, and now she is the Eastern Regional Outreach Coordinator. Kind of like she said yesterday, the main part of her job is trying to help inventors and provide information about the Patent and Trademark Office. So that's what she's going to do here today. Feel free to post your questions. We'll try and get to as many of them as we can. And take it away, Elizabeth.
Thank you, Kathy. Thank you, Carmine. It's a pleasure to be with all of you again today. And congratulations to all of you on your fantastic pitches yesterday. As Carmine alluded to, it wasn't an easy decision to ultimately land on the Rate Caddy because you all did a great job and you all have remarkable and very unique products, unique from one another. So it was a pleasure to kind of get some insight into your creative mojo and where you're thinking and what space you're inventing in relation to the golf world. As Kathy and Carmine have mentioned, today we are going to do a deep dive, or as much as time will allow, talking primarily about patents, but talking about intellectual property and why it's important to you as a small business owner. Because we have an intimate audience here today, I hope this will be a conversation. I hope it will be a dialogue, and I hope we can answer as many of your questions as we can. I recognize that some of you have meetings and other things associated with the show and may have to drop off. I know we only have an hour together, so we're going to try and get as far as we can. But please always consider myself and my staff, as well as the team at the UIA, to be a resource to you. So if we're not able to get to your specific question today, or perhaps if it's a question that you want to keep more confidential and you want to ask outside of this forum, please don't hesitate to contact me, or again, contact the UIA. So with that, I am going to share some slides. Let's see if I can do this correctly. It's always the challenge. And Kathy, I'm going to have you tell me if you can, in fact, see my slides, make sure we're up and running.
Yes.
Fantastic. Okay, and I'm going to rely on Kathy to help facilitate those questions because the way my computer is set up, I can only see my slides. So I'm going to just jump right into this, but please don't hesitate to ask any questions. So the title of my presentation is IP Strategy as a Business Strategy, and that truly is the case. And I say that because oftentimes in talking to independent inventors and small business owners, IP strategy is a rainy day strategy. It's one of those things that they're going to get to when they have more time or more money or a better appreciation and understanding. And while I can appreciate that as a small business owner, you're focused on a huge number of things: opening the doors, finding employees, how do you commercialize and market your product, how do you manufacture your product. But sometimes by delaying in protecting your intellectual property, you can in fact be precluding yourself from protecting your intellectual property. And we'll talk a little bit more specifically about that later in the presentation. But for those of you who aren't familiar with the U.S. Patent and Trademark Office, and I think many of you are from your presentations yesterday, a number of you have either issued patents or provisional patent applications. The USPTO is America's innovation agency. We issue patents and we federally register trademarks. We are responsible for fostering innovation and growth in the US economy. These are just some quick stats to tell you a little bit about our agency. We won't dwell on them, but just let me tell you that our agency is approximately 13,000 people, but we are one of the best kept secrets of the federal government. 13,000 employees who, again, issue US patents and federally register trademarks. And we do that through the work of fantastic employees, nearly 8,500 engineers and scientists reviewing patent applications, and nearly 600 trademark examining attorneys. And I tell you, they are busy every day of the week. Each year, we receive over 600,000 US patent applications and nearly 500,000 trademark applications, and that it grows each and every year. We have not seen a year of downturn, in fact, and it does significantly grow. And we put programs and initiatives in place so that these growths in filing in patents and trademarks don't impact you as a filer. And we'll talk about some of those programs and initiatives. So as you can see, the issuance of patents has exponentially exploded over time. When you look at the fact that it took us nearly 100 years to issue the first million patents, but yet look how exponentially that growth has proceeded and much more quickly. It was during the tenure of our patents director, Director Andre Yanku, that we issued patent number 10 million. And I can only speculate that it's not going to be that long before we issue patent number 11 million. And with that, there is this certain level of excitement. There's the excitement of that amount of creativity, invention, innovation, and ingenuity that's taking place. Now, keep in mind, one does not have to be a US citizen to file a US patent application. And in fact, about 50% of our applications are received from individuals from outside of the US. To bring this into context of what we're talking about today, and specifically golf technology, I've taken a look over this last 20-year period from the year 2000 to 2020, just to show you a reflection of the golf art. The blue line is the number of patent application filings we have had in golf-related technologies. And that could be clubs, that could be balls, that could be training devices. As you can see, and one might easily guess, the number of filings exceeds the number of issuances. And that's because we don't issue a patent for each and every application that's received. In fact, right now, we are issuing about 50% patents for the number of applications are received. So now whether you take that as a positive or a negative, right now you're running about a 50-50 chance that you might receive a US patent with respect to your filed application. But it's interesting to me that there has been a growth over time, and it's been a steady growth, but it's not been an exponential growth. But just to note that you're in an area certainly of high volume filings. Now, taking again the importance of intellectual property from that 30,000 foot level, why is IP important for us as a nation? Well, it's important because it creates jobs and it creates higher paying jobs. It also lends itself to a huge portion of our gross domestic product. So by moving invention and innovation forward, we continue with the growth of the US economy. Now, when we talk about intellectual property, we basically talk about four different things: patents, trademarks, copyrights, and trade secrets. Now, as you can see, this chart suggests that there's 6 types, and that's because we've also broken down patents into utility patents, design patents, and plant patents. What's important from this chart, and I know it may be hard to read on your screen, and you will be provided with a copy of these slides if you'd like. Each of these forms of intellectual property protects something very different, and oftentimes they have very different durations. As you can see, utility and plant patents are good for 20 years from the date of filing. Plant patents are good for 15 years from the date of issuance. Copyrights are good for the life of the author plus 70 years, meaning that creative individual, that copyright is good for their life and the life of their heirs, those 70 years following their death. Trade secrets, incredibly, can be good forever if you're able to maintain it as a trade secret, and thus incredibly valuable because of the potential longevity of that intellectual property protection. Trademarks, similarly, can be good forever if you continue to use that mark in commerce and you continually renew it with the U.S. Patent and Trademark Office. So let's talk about patents. And again, I know some of this may be preaching to the choir. Some of you have already gone down this path and started or obtained a U.S. patent. But a U.S. patent is a property right, and it's a property right issued to you, the owner, from the federal government. And it provides you with the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. And it is for that limited period of time. As I said, for utility patents, it's 20 years from the date of filing. For design patents, 15 years from the date of issuance. It's important to know, and we're going to talk a little bit later about some international aspects, but patents, like every other form of intellectual property, are territorial, meaning they only protect you in the country or area in which that right is issued. So for example, if you have a patent that's issued by France, it only protects you within the country of France. We will talk a little bit about prior art and how that can impact what perhaps seems like an extension of your patent, and we'll talk about that as well. Now, again, this is a government grant of a property right. So with it, there comes some complexities. Think of the last time you bought or sold a piece of real property, a house, a car, a boat. How many times did you have to sign on the dotted line? Well, because of this exchange with the federal government, there is some complexity involved. And this is why a majority of applicants use the services of a registered patent attorney or patent agent. Again, because of the complexity of patent law and wanting to obtain the greatest protection. As I said, when showing that chart, there are 3 types of patents: utility, design, and plant. Now you'll notice here, I am not referring to a provisional patent, and that's because there is no such thing. And that is because there is a provisional patent application. And in fact, my colleague Kathy is an expert on provisional patent applications and used to speak on the topic for the U.S. Patent and Trademark Office. A provisional patent application is not a patent, it's a placeholder that puts on record with the U.S. Patent and Trademark Office the start of your idea, the beginning of the process, and allows you to use the term patent pending. But it is in fact not a patent, it is not enforceable, it is only when one receives a U.S. patent, utility, design, or plant, that you have something that is enforceable. I apologize, there's a duplicate slide there. Now, why get a patent? Well, there's a lot of different reasons. It can be used to ensure that others cannot make, use, or sell, or offer to sell your invention. It's a marketing tool. How many of us have ever watched Shark Tank? How many times do those sharks ask the people coming before them, what's your intellectual property portfolio? Do you have a patent? You can use that to market your invention. Also keep in mind that once a U.S. patent issues, it joins this enormous repository of technology, perhaps the largest repository of technology the world has ever known. As I mentioned, we've issued over 10 million U.S. patents. Think about the technology that's encompassed within those documents. It can be used as collateral to obtain funding and create revenue through sale or licensing, just like a piece of real property. It can also be for personal or professional growth. My father, in fact, has a patent which has never been commercialized, but he's never been so proud as the day that he received that U.S. patent. So why do startups file patents? They do it in part for the same reason that large industry clients do. It's attractive to investors and buyers, and as a form of property, they can add value to a company's assets. Again, it's part of your property portfolio. It adds to the value. So when you do, if you are interested in licensing or selling your company, you can show that you have this asset in your portfolio. So when should you file? It's important for us to keep in mind that the United States is now a first inventor to file system. That was not always the case. We used to be a first to invent system. However, to get in better alignment with the rest of the globe, we have transitioned to a first inventor to file. Now, that doesn't suggest that it's a race to the patent office, but in a certain sense, it is. You do want to file before making a public disclosure, and we're going to talk about that very specifically in just a minute. If you only want U.S. protection, you can file within 1 year after public disclosure, and we'll talk about international implications as well. In the US, we have something called a grace period. Once you make a public disclosure, you still have the right and ability to file for a US patent if it is done within 1 year of that public disclosure. So what are the risks of disclosure? Let's first, before we do that, talk about what is a public disclosure. This is a very gray area, so I can't give you any definitives as to yes, this would constitute a public disclosure. No, this would not constitute a public disclosure. But here are some examples of what could potentially be a public disclosure. Displaying your invention at a trade show, posting your invention on the internet, offering to sell your invention, a description of your invention in a newspaper or a journal article, publicly demonstrating your invention. What goes to the concept of public disclosure is how substantially do you disclose your invention? If you were to merely say to someone, I've invented a new bicycle, are you making a public disclosure? Probably not. If you say to someone, I've invented a new bicycle and I have some drawings right here, would you like to see what it looks like and how it operates? Would that be a public disclosure? Potentially. It can also in part depend upon that individual you're showing the information to. Do you have a confidential agreement with that individual? Are they a spouse? Are they someone who has signed a non-disclosure agreement? So what can you say before filing? It must be very high level. It must not provide any depth of understanding. You cannot describe your invention with such specificity that others can make and use your invention, because that's what you're going to do in your patent application. When do you know you've said too much? Well, let's think about it like this. If somebody could take your disclosure and recreate your invention, you've certainly said too much. So can you just keep it a secret? Well, you certainly can and you should, but this is also where it's a great opportunity to talk about filing that provisional patent application. Because once you have filed that provisional patent application, again, you have something on file with the US Patent and Trademark Office, drawing your line in the sand as to what your invention is. You can begin to use the term patent pending, and you can begin to talk to others, whether they're investors or whether they're manufacturers, or whether it's the public because you're seeking to know if anyone's interested in your product. You can begin to have those conversations. Now, of course, if you do decide to move forward with your invention, you do want to take it to that next level and file that non-provisional application. It is important to note that if you are interested in filing a design patent, you cannot use the provisional patent application. Provisional patent applications are only available for utility patents and plant patents.
Elizabeth, real quick before you move on,
Please.
Can you talk a little bit about the number one thing that we used to talk to inventors, that you filed the provisional application, and how long do you have to file the non-provisional, and what happens if you don't?
That's a great question, Kathy, and I appreciate that. And actually, it's perfectly timed with this slide.
Oh.
So when you file that provisional patent application, it is good for 1 year with the US Patent and Trademark Office. It is kept on file with the office. It is maintained in confidence. It is not looked at. It is not touched. It is not viewed by anyone. Now, if you want to then proceed to that non-provisional, you need to file the non-provisional within that year that the provisional patent application is alive. Let's say that it's alive because after that 1 year, it is technically dead. Now, when I say dead, we don't purge our files, we don't clear out the databases, but you can no longer rely on that filing for a non-provisional patent application. Now, let's say you get to the end of your year of your provisional patent application and you're still not ready. The question always arises, what do I do then? Well, you can go ahead and file your non-provisional and proceed and try and get your act together. You can file another non-provisional with a caveat. If you file a second provisional patent application, you are starting your time clock over. Keep in mind, if you file that provisional patent application and you file the non-provisional within that year, and you receive a US patent, effectively what you've accomplished is a 21-year patent. You have gained an extra year on your patent, other than unlike people who have just filed the non-provisional and who have a 20-year patent. Now, if you have to file a second provisional patent application and restart your time, again, you would have 21 years, but you won't have 22 years. So I hope that concept is clear. Now, let me also be clear, though, to say that you do not have to file a provisional patent application. That is not a required step in any way. One can go directly to filing the non-provisional. If you are set and ready and you want that US patent in your hand, then perhaps you don't want to take that step of filing the provisional patent application, because in some instances, it can cause you additional financial outlay. You're preparing two different applications. Now, can you take that provisional patent application and convert it or use it for filing your non-provisional? You can, but generally, and this is anecdotally, generally, people's provisional patent application does not meet all of the criteria of the non-provisional. So generally, the non-provisional is going to require some additional work. So keep in mind, if finances are an issue, do you in fact need the provisional patent application? And maybe you do. And it is a low cost of entry and a low level of entry into the system. You don't have to have patent claims. You don't have to have all of the formalities of the non-provisional. But if finances are an issue and you know you want to go and seek a US patent, you may want to skip the provisional patent application. Again, it's a good conversation to have with a patent attorney or patent agent to specifically spell out your situation and what your needs are. Provisional utility applications, as we've kind of touched on and already spoke about, they have simplified filing requirements. They require a specification, the same disclosure as the non-provisional, a disclosure that provides such specificity that others can make and use your invention, and it has to be an enabled written description. Again, one enabling others to make and use the invention. You must file drawings if your invention can be depicted in drawings, and you must pay a filing fee and have a cover sheet. When specifically looking and working in the area of golf technology, I had the opportunity to meet with some of the patent examiners and supervisory patent examiners that work specifically in our golf area. Remarkable group of individuals, and some of them have been in that art for over 20 years. They've seen it all. I asked what some of their best suggestions were for those of you who are working in the golf technologies. And they said, first and foremost, do your homework. Because it is an area of active invention, do your homework and know what is in your space of endeavor. If you've invented the rake buddy, look to other golf rakes, golf implements that can help maintain and manicure the sand. If you're inventing in the club art or the golf ball art, look to see what else is in your field of endeavor. Use it both as a jumping off point for you to improve upon, but also use it as a place to define the parameters of the work that you're doing. Use the language of the art. In filing a US patent application, you are invited and entitled to be what we call your own lexicographer. You can use your own language to call things what you would like. However, the caveat to that is you should use the language of the art. If you've invented a new golf ball, why would you call it a golf, comb? If the art recognizes the words golf ball, and that is a term of art, just because you have the ability to be your own lexicographer, don't stray outside of the parameters. It's going to cause headache and heartache for you. Spell out criticalities where any exist and be specific. They cited to this, particularly when you've invented perhaps a new tool, a new golf club, something where a range is required. The materials you're using provide a range of flexibilities, a range of abilities. Be specific in calling out what those critical features are and why they are critical to the success and accomplishment of the particular invention. They also pointed out, and this is something that may not be new news to any of you working in this space, is that over time, they have seen the most significant growth result from new materials. For example, in shafts, in golf club shafts, when we transitioned from wood to metal to composites, golf balls when have transitioned significantly over time, and then also with player preferences. You know, when Tiger Woods hit the scene, everyone wanted to be using the same equipment as Tiger Woods. So that really exploded the industry in developing new golf balls and golf clubs, because everyone wanted to have that same success that a player like Tiger Woods does. So when considering international filing, because if we recall, I said that patents, like every other form of intellectual property, patents are territorial. So that patent protects you in the country in which it is issued. So how do we think about international filing? How do you know when and where to file? Well, anecdotally, what's generally used as a rule of thumb is you want to consider protecting your invention in the countries where you will be selling, in the countries where you will be manufacturing, in the countries where your largest competitors are. So looking at the golf technology area, you may want to see those countries, whether it's Scotland, Ireland, the UK, France. Where are there significant golf populations? Where is the R&D being done? Where are the technologies driving from? Where is the inventive population that's in this field? Consider protecting yourself in those areas. So who grants patents in countries outside of the U.S. Patent and Trademark Office, outside of the United States? Well, in some instances, there are national patent offices, just as the U.S. Patent and Trademark Office. There is the Japanese Patent Office, the Korean Patent Office, but there are also regional patent offices, the EPO, and as you can see, several other examples here. And they would cover a region of countries, and they examine applications for the entirety of that region. Now, the challenge in patenting internationally is that it becomes incredibly expensive and incredibly complicated. And this is where I can't strongly enough encourage you to use the assistance of a patent attorney or patent agent. Can you in fact patent worldwide? You could, but it would be an incredibly expensive endeavor and incredibly unnecessary. But again, anecdotally, think about the fact that you want to file where it makes sense, where it fits your business strategy. There's currently no worldwide patent, and you know, Kathy, I don't know if in our lifetime if we're ever going to see one either. You know, maybe someday. We do continue to harmonize the laws across the globe, as intellectual property is a global commodity, but there is currently no worldwide patent. So as I said, some of the business considerations are market size and potential of that country. Maybe golf is all of a sudden taking off in a country where it hasn't been prevalent before. Manufacturing potential, industry size and growth, competition activity, patent procurement costs. Always keep in mind the cost, because the U.S. Patent and Trademark Office, you know, I know people say patenting is expensive, but the U.S. Patent and Trademark Office is in fact the cheapest intellectual property office in the world. And while we're on the topic of cost, and not to throw our intellectual property bar, our patent attorneys and patent agents under the bus, I will say when people talk about patenting, the majority of the costs are in those legal fees. Now, with that said, I've already said to you more than once, we strongly encourage you to use a patent attorney or patent agent. It's just like getting a root canal. Could you do it yourself? I don't know, maybe. Probably not advised. So get professional assistance. There is the same level of complexity when, you know, securing real property.
So Elizabeth, you should also mention the fact about where our fees come from. I don't mean ours. I'm sorry, I don't work there anymore. Where your fees come from.
Well, I thank you, Kathy. And that is always a curious feature and something that not everyone knows. So the U.S. Patent and Trademark Office, while we are a federal agency, we are part of the larger U.S. Department of Commerce. We are totally a fee-funded agency, which translates into the fact that all of our fees come from our users. They come from our patent and trademark filers. We do not take any taxpayer dollars in order to do our work. And I like to point that out because we are so novel in that feature. There's very few other government agencies like that. And it shows that we in fact run our agency much like a business. So oftentimes when people will joke, well, there's my taxpayer dollars at use. I have to take a step back and say, well, not really. But nevertheless, we are fully user fee funded. Again, when we talk about international filing, there are complexities because there are different standards of patentability. You know, in the United States, in order to receive a US patent, your invention has to be novel. It has to be non-obvious, and it has to have utility. Those are our criteria. It has to be novel, not thought of before. It has to be non-obvious. It cannot be an obvious variation on existing technology. And it has to have a utility. It has to have a purpose. We don't patent, perpetual motion machines that have no purpose. That is not true in other countries across the globe. So this again lends to the complexity of international patenting. So there may be patentable subject matter differences. In the US, we can patent business methods. We can patent software. This is not true necessarily in all countries around the globe. Prior art differences, as I mentioned to you, the grace period. In the US, once you have made a public disclosure of your invention, you have 1 year to file your patent application. If you disclose your invention prior to filing, there is no other country in the world that will allow you to file once you have made a disclosure. So this is where it's important that you determine your intellectual property strategy right up front. Because if you're thinking about filing in France, do you want to be showing your invention at a trade show without having secured or filed for that French patent? Probably not, because you are probably going to preclude yourself from being able to do so. So this is important where you determine the strategy ahead of time before leaping in. And I know that's hard. I know that's hard because, again, as a small business, you have so many considerations and so many things to consider and evaluate and put your funding and resources to. It's also important to note that types of protection differ from country to country. So to know these nuanced differences, this is where that patent attorney or patent agent is going to come in handy. As I said, the grace period differs in different jurisdictions. So very, very important. Before we close out today, I do want to talk to you about some USPTO resources. Because right about now, your head may be spinning and you may be thinking, oh my goodness, what have I gotten myself into? Or what am I about to get myself into? And who's here to help me? Well, as you know, and as I've said, probably nearly 100 times right now, a US patent attorney or patent agent can be of help to you. But we would also like to have you see the US Patent and Trademark Office as a viable friend and collaborator in this process, and the UIA as well. Organizations like the United Inventors Association are there to help inventors. They're there to demystify the process and to help connect you with resources, help connect you with others who have gone down this path. So perhaps you could avoid some of their pitfalls or learn from their mistakes, but also learn from their successes. My office is the East Coast Regional Outreach Office, and we are located at the USPTO headquarters, which is in Alexandria, Virginia, or directly outside of Washington, D.C. And while we are currently closed to the public, as most other government agencies, we are still working at full speed. We are all teleworking from our homes, and we do look forward, though, to the day when we are back in the office. And once we are in the office, we welcome you to come in and visit us. You can meet with us directly. You can use the resources of the U.S. Patent and Trademark Office, including our public search facility. You can meet with examiners directly and enjoy our public space. We have a wonderful museum on campus, the National Inventors Hall of Fame, and I encourage you to visit that again when our facilities are open. As I know, many of you are from different parts of the country and some of you outside of the US. We do have regional offices located in Detroit, Denver, Dallas, and San Jose. So for James, I hope you'll have the opportunity to visit our San Jose office sometime. We do also have a valuable resource called our Inventors Assistance Center, and they take phone calls every day of the week from 8:30 to 8, and there's no question that's too hard or too silly. They welcome each and every one of them. It is staffed by a wealth of individuals who have extensive histories and careers in the U.S. Patent and Trademark Office. And they welcome each and every call. So I strongly encourage you, no matter what the question is, to start with our Inventors Assistance Center. We also have, and we like to promote because it's not always well known, is that we have a patent pro bono program. This is the result of the America Invents Act of 2011. As part of that act of Congress, Congress encouraged and incentivized the U.S. Patent and Trademark Office to work with legal organizations across the nation to set up regional and state pro bono programs, where this nationwide network is able to assist financially under-resourced independent inventors and small businesses. Now, one must apply to the program and one must be accepted into the program to take advantage of it. And again, there are programs which cover the entirety of the nation. As you can see from this slide, there's a number of programs that are, again, either state or regional programs, and each one has slightly different eligibility requirements. However, there are a few basic core requirements, the first of which is that you have more than a mere idea. You, in fact, have to have an invention that could be commercialized, because we would love to see inventions move forward that could create a small business, perhaps grow a business, and then even result long-term in an industry. Now, when you say, what do you mean by not just having a mere idea? And I'll give you one of my favorite examples. I have a great idea. I'm sure we all do. I have a great idea that I would like to invent a time machine. I'd like to invent a time machine that I could go back and talk to Abraham Lincoln, one of my huge favorites, George Washington, Harriet Tubman, so many people. Now, do I have any clue as an inventor how to invent a time machine that I can take to travel back in time? No, I don't. So I have an idea. I don't have an invention. In order to participate in the pro bono program, you must have an invention. You also have to have some skin in the game, and you can show that skin in the game, so to speak, by having either filed a provisional patent application or having completed an online course available on our website. And then you also have to be under a certain financial cap, and that differs from state to state, but on average, it's 300% of the median poverty level for your area. I encourage you, if interested, visit our state resources map on our USPTO homepage and find the program in your area and see what they require. Now, we also have something called law school clinics, and these are also located across the nation. And oftentimes individuals who make too much money or who have too much money and can't take advantage of the pro bono program can sometimes receive pro bono assistance from a law school clinic, where students are acting under the supervision of a law school faculty clinic advisor, and they will help assist you with filing your patent or perhaps even your trademark. We also have something called Patent and Trademark Resource Centers, or PTRCs. These are over 80 libraries located across the nation, generally in public facilities such as universities. These libraries are critically important because they each have one or more librarian who is trained in patent and trademark searching and has an appreciation for the role and importance of intellectual property. I'm so sorry. So sorry, that would be my dance. Yes, so there we go. Back to the PTRCs and how critically important they are. Now, many of these facilities are also closed due to the pandemic, but some are still providing online assistance. Again, these librarians are incredibly gifted in helping you to establish a good quality patent or trademark search. I bring this up, it's a little bit more in depth, but I do bring up our Track 1 prioritized examination for any of you who find yourself in the situation where you need to receive a patent fast. On average right now, it is taking approximately 2 years for people to get through the application process once they have filed that non-provisional patent application. Now, you may find yourself in a situation either because of a competitor or because you want to go to market, you want to manufacture, you want a license, that you need your patent more quickly. If you participate in our Track 1 prioritized examination procedure, for an additional cost, and for a micro entity, that's $1,000. For a small entity, it's $2,000. We pledge to you that you can receive the final determination in a year or less. Sometimes these patents have been issued in as little as 5 months. So it's just something to keep in mind. It does, again, come with an additional price tag, but sometimes you find yourself in the situation where it's just what you need. When I was talking about Track 1, I mentioned that our micro entity fee for Track 1 is $1,000. And if I were to have told you the large entity fee for track 1 was $4,000, that would reflect that our micro entity filers pay most patent fees reduced by 75%. If you think you might be entitled to microentity status, I'd encourage you to visit our website because it does require that you file a certification statement. And that certification statement sets forth that you qualify as a small entity, you've not been named as an inventor on more than 4 previously filed patent applications, and you are under a certain financial cap. Again, we do not want people to leave inventions and innovations on the kitchen table, on the garage workbench for lack of funding and ability to bring them forward. So we have this microentity status that, again, if you're entitled to it, I strongly encourage that you take advantage of it. I'm going to leave you with a few other USPTO resources. And as I mentioned at the very front, I will provide these slides to the UIA, so then you will also have them as a resource for your use. With that, I want to be sure and leave you with the phone number for my office, our website, which is www.uspto.gov, and my direct email address as well, elizabeth.doherty@uspto.gov. You're welcome to reach out to me on LinkedIn. You're welcome to email me. You're certainly welcome to call me and my team. And I wish you all the best of success in pursuing your inventions. With that, I'm going to stop sharing my screen.
So Elizabeth, real quick before we let everybody go. Now, a couple of people had issued patents.
Okay.
And can you remind them that once the patent is issued, the game is not over?
Kathy, that's a great point, and I appreciate you mentioning that because more than once we've had people come to us very surprised.
Yeah.
So when one receives a U.S. patent, we do have something that is called maintenance fees. And this is a result of how the U.S. system is set up. We have a system where the cost of entry into the system is as small as possible. Our fees are all set at what we call cost recovery. We only charge you what it costs to do the work itself. But with that said, we, in fact, probably don't really charge you what it costs to do the work. We charge you less because, again, we don't want people leaving inventions and innovations on the kitchen table, on the garage workbench. We want inventions being brought forth. So in the US, our system is a very low cost of entry, and we hope that we will make up that cost, that fee on the back end through what's called maintenance fees. We charge maintenance fees at 3.5 years, 7.5 years, and 11.5 years. And they subsequently ramp up the longer your patent is in force. And it's kind of a common sense. I'll spell it out and you'll see how it in a way makes sense. The fees get substantially larger because the hope is, and oftentimes is the case, that as the longer your patent is in force, the more success you're experiencing. When you first receive that patent, well, you're probably not making any money. You're probably just working that deal. You're making that deal. You're licensing it. You're beginning to manufacture. Hopefully at 3.5 years, maybe you're selling it on the internet. Maybe at 7.5 years, you're on the internet and you're in the big box stores. And then come 11.5 years, you are ubiquitous in the field. Everyone knows about your product and it's everywhere. Now, with that said, if somewhere along the line you decide you no longer want to pursue this invention, the industry has passed it by, the technology is no longer necessary, perhaps a competitor has crowded you out of the space, you always have the choice to not pay a maintenance fee and to go ahead and allow your invention to fall into the public domain. And that's what happens when a patent expires or when you fail to pay the maintenance fees. Your invention becomes part of the public domain and individuals can make, use, sell, or import your invention without your permission. Now, a corollary question that I just thought of, Kathy, given our conversation about maintenance fees, is people oftentimes ask me, Liz, my patent's about to expire. Can I renew it? Because I want another 20 years. And unfortunately, the answer is no. Now, that's not to say that you couldn't further refine your invention and add a new aspect and perhaps seek another patent. But you cannot renew a patent.
Good point. Good point. Thank you, Elizabeth. Does anybody have any questions? Are we good? I'm going to get you slides. I will get the slides.
Perfect.
Thanks, Elizabeth. I know you have another meeting lined up.
Kathy, I really enjoyed once again being with the UIA, being with our fantastic inventors and innovators. It's always exciting to be with you, to see what the creative minds are coming up with. And to
Yeah.
know that there might be hope for my golf game with some of the, I mean, I'm looking forward to getting back out there, especially as the weather gets nice. And I hope I'm going to have a few of these products in my arsenal to help improve my game.
Great. Thank you so much, dear.
You're welcome. I wish you all success.
Great.
Thanks,
I wanted to mention to you guys, if you're not already signed up for the United Inventors Association, go to our website, sign up as a member. A lot of our information on things that we're doing gets posted there. Like this is an educational series. It's one of our educational series that we're doing. Interesting enough, the next one will be on Thursday, February 4th, and it's going to feature a woman named Marcy McKenna, who has a number of products that she sells on HSN. But the real focus of it is going to be on women inventors. So, I mean, it might be worth jumping on. You never know. So if you guys don't have any questions, it was great to meet you all. Michael, I will send you the certificate.